I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Welcome everyone to the Judicial Candidate Forum. I am Judy DeAngelis Small, President of the League of Women Voters of the Space Coast. I will be the moderator this evening, and Suzanne Taylor, our first Vice President, will be vetting questions, looking out for repetitions, relevance, and language. For 106 years, the League of Women Voters has been a nonpartisan, activist, grassroots organization that believes voters should play a critical role in democracy. Over the last century, we've fought for election protection, reforms to maintain a democracy, and equal access to the ballot, all while maintaining our commitment to nonpartisanship and fostering an informed electorate. The League does not support any candidate. Our role is to offer the public a chance to learn more about each candidate, empowering them before they go to the polls. The leaders we elect make decisions that affect our daily lives. Elections are our chance to stand up for what matters most to us and to have an impact on the issues that affect us, our communities, our families, and our future. Florida is a closed primary state. However, some races are nonpartisan, such as school board and judicial races. These races may be decided in the primary, so I encourage all voters to vote in the primary. This evening, you will hear from judicial candidates for Group 4 and 13 on the Circuit Court number 18. Each candidate will have 2 minutes for an opening statement, and each will have 90 seconds to answer each question. And you will have 2 minutes for a closing statement. Lisa Fowler, down in the front row there, is our timekeeper tonight. And she will show you a yellow paddle when you have 20 seconds left to finish up. And then the red paddle will be when your time is up. We'll start alphabetically. Hang on. Suzanne is going to explain something maybe we all don't know. Me too.
That sounds really mysterious. It's not at all. So some people expressed as they came in that they didn't understand the difference between circuit court and county court, which I'm an attorney, so it's secondhand nature to us, but it's a really good question. So I'm going to make a really basic attempt to explain the difference. There are two primary differences between county court and circuit court, and one is in terms of what they cover, the area that they cover, and the other is in terms of what types of cases they cover. So in terms of area, county court is just Brevard County. Circuit court is the circuit, which is Brevard and Seminole County. So a circuit court judge could be called to go to Seminole County, and there are Seminole judges that primarily work over there, but they can come over to Brevard. County judges just stay in the Brevard County. The other is in terms of the type of cases. So county court is a little bit lesser importance of cases. For example, misdemeanors, while circuit court is felonies and death penalty. Small claims court in county court, landlord-tenant, and lower amounts of civil cases. So felonies, death penalty is pretty serious, but also higher value civil cases, and juvenile delinquency and juvenile dependency. Juvenile dependency, for those who don't know, is when the Department of Children and Families removes children from their parents. So those types of serious cases. So that's a very quick thumbnail sketch of what the difference is.
Thank you. We'll start alphabetically, and if you go first, then the next question you'll go last, and it'll just rotate. I think you'll do it. Okay, Ms. Span, you're up first. Your opening statement.
Thank you. Hi, I'm Andrea Fant. I was born and raised in Melbourne. I've been an attorney for over 16 years. I have practiced in civil, family, and criminal law. I have been before the county court, circuit court, as well as an appellate court. For the last 7 years of my career, I've served this community as an assistant public defender, working cases, as she mentioned, felony cases. I've done everything from misdemeanors up to murder and homicide cases. And I've argued before the Court of Appeals as well. What I stand for, obviously upholding the law, and that is what a judge should do, preserving the integrity and the confidence that we should have in our justice system, and being fair and impartial. And so I'm asking for your vote. It's August 18th. Please vote Andrea Fent for Circuit Judge.
Thank you. Mr. Freeman.
My name is Larry Freeman, and I'm running for Circuit Court Judge. I'm new to this. I've never run for any office before. Can you hear me now? Okay. I haven't run for office before. This is a new thing to me. My first area of expertise was engineering. I have a bachelor's, master's, and PhD in engineering. I worked closely with legal offices in many of the companies I worked with, but never as an attorney. And I went on and decided to get my law degree here in Florida. I have a law degree from Berry Law over in Orlando. I have a small office in downtown Melbourne where I practice primarily civil litigation. I originally intended to start out doing intellectual property and the like that, but people kept coming to me asking for help, and there's not a whole lot of intellectual property work in the area, so I naturally gravitated towards that. The reason I'm running is I'm concerned about our Constitution, I'm concerned about our laws, I'm concerned about our Florida freedom. I'm worried that people are turning off, that they feel there's an establishment, that they don't get heard, and I believe that is the case. And so I'm running to present to people a different kind of judge, a different option, a different skill set, analytical, problem solving. That's what I bring, and I'm asking for your support.
Thank you. Mr. Gaspar.
Good evening, everyone. I'm George Gaspar. I'm legal counsel for the Brevard County Sheriff's Office. I'd like to take you back in history a little bit to talk about how I got to where we are today. I got my Bachelor of Science degree from the University of Central Florida in legal studies with a certificate in trial advocacy and litigation. I was also on the trial team while I was at UCF. From there, I moved on to Barry University School of Law, much like Mr. Freeman, where I graduated with my Juris Doctorate and a certificate in children and family law, while also taking book awards, which are an award given to you for having the highest degree in a specific class in your section of students. I got book awards in trial advocacy and legal history. From there, I became an assistant state attorney, and I served in Brevard County as an assistant state attorney from the end of January, beginning of February 2014, all the way through October of 2020, when I got called by the sheriff's office to come over and become in-house legal counsel. At the state attorney's office, I handled everything from misdemeanors all the way up through first-degree felony murders. I've tried most manner of cases, or I've experienced almost every type of criminal case one could see. When I left the state attorney's office, I was in the child abuse, sex crimes, and homicides unit. And I was also one of the training attorneys. So when I was in misdemeanor, I would get all the new hires and they'd go, "Here, George, teach them. Teach them how to try a case." And so I did. And so I was constantly assigned new hires to teach how to be attorneys, how to try a case. At the sheriff's office as in-house legal counsel, they created a role for me. And there I handle all manner of civil matters. Civil, family, levies, writs of attachment, you name it, in addition to criminal law, in addition to constitutional law, in addition to property and probate, family, guardianships, you name it. Because of the breadth of the practice area that the sheriff's office encompasses, I get questions in almost every practice area because they need help in understanding what the law is. Thank you.
Thank you. Mr. Siegel?
Good afternoon, folks. My name is Rob Siegel. I've been a circuit judge for the past 8 years. Presently, I am the administrative judge of the Family Division for Brevard County. So in addition to my caseload, I supervise 3 other judges, 3 general magistrates, and a hearing officer, and taking care of all the family law cases that hit the circuit court, which is one of the divisions that Ms. Taylor forgot to mention. But we handle divorces, child custody, things of that nature. Before becoming a circuit judge, I spent 4 years as a general magistrate. A general magistrate is an attorney who performs the functions of a judge, but under the supervision of a judge. So a general magistrate conducts hearings and makes recommended rulings, which are handed to a judge. The judge reviews them and approves them. For the 23 years before that, I was a trial lawyer. That's all that I did. I tried cases in criminal law. I tried cases in family law. I did argue appeals in both the 4th and the 5th District Court of Appeals. I've argued in front of the Florida Supreme Court. I used to be a Florida Supreme Court certified mediator while I was in practice. Now that I'm on the bench, I am certified by the Florida Supreme Court to serve as a mentor judge, meaning that when new judges come onto the bench, I'm certified to teach them how to do what it is that we do. I supervise the adult drug court right now, which is a fabulous program where we take individuals that are charged with low-level drug possession offenses, and rather than putting them through standard prosecution, we give them the opportunity for treatment. We give them the opportunity to treat their addiction. We help them find housing. We help them find homes. We help them find jobs. We help bring them back into the community so that they can become productive members of the community and reduce our crime rate. I've been doing this a long time. I'd like to think I know what I'm doing. I'm doing it very well. Thank you, folks.
Thank you, Mr. Siegel. The first question will go to Mr. Freeman. And it'll be the same question for all of you. Okay, so, what is your philosophy of the judicial role? What is the greatest challenge of this role?
Integrity. Integrity, consistency, fairness, equality, and not only that, but the perception of it, to follow the law, follow the statutes, the intestinal fortitude to make decisions that may not be popular. I'm sorry, I'm not used to kneeling down here, but I'm sorry?
Or pull it close.
I didn't know if it was gonna fall apart on me or not, but having the intestinal fortitude to make unpopular decisions, if that's what following the law, following our Constitution requires, following binding precedents, following the statutes as written, not interpreting the law or legislating from the bench, understanding that things that people see influence how they perceive fairness and equality. And knowing that, somebody who comes before you who, has been there before or shows, some kind of familiarity that an individual does not, making sure that that person understands that they are still going to get the fairness that they deserve and their rights are going to be protected. That is paramount to me. And, is regarding time or consequence.
Just push the red button.
It did, no. Anyhow, that's my judicial philosophy.
Mr. Gaspard?
My judicial philosophy is the faithful application of the law as it's written. Sounds easier said than done, but candidly, folks, that is the primary purpose of the bench. If we don't strictly adhere to the rule of law as it's written, without consideration of our personal feelings, we're doing a misjustice. And I've seen that happen. I've seen it go both ways. I've seen it inure in the favor of a plaintiff. I've seen it inure in the favor of a defendant. It's improper. And so I think one of the fundamental core features of my judicial role, were I to be elected, would be to ensure that the law is enforced, to ensure that I am not allowing any personal feelings to impact my reading of the law, and to understand, there's actually a great quote on this. Justice Scalia basically said, the judge who likes every decision he makes is a bad judge. Because if you like every single decision, that tells me you're bending something to make it fit the law. And that should never be the case. It's incumbent upon the bench to follow the law as it's written and not to legislate or change from the bench. Thank you.
Was your
Yes. What is your philosophy of the judicial role, and what is the greatest challenge of this role?
We're not an appellate court, we're trial courts. And the one thing that I've noticed, having been on the bench for as long as I have, is that every single individual in that courtroom is a person. Whether it be the judge, one of the parties, the courtroom deputies, the attorneys, everybody is just a person. And it's very hard to be in a situation like that. You compound that with a situation where a litigant appears before you and they don't have an attorney, and they're sitting across the courtroom with somebody who is represented by an attorney. It's real easy to say, hey, I'm going to be fair, I'm going to be impartial. But how do you do that when you have to follow one set of rules and you've got one person that's represented by an attorney and one person that's not? And I will tell you that it takes a great deal of finesse, it takes a great deal of skill for people to understand and feel as though they're being heard and they are being treated fairly. We're all smart people. We understand the law, we know the law, we can read the law, but it really takes a lot of skill and a lot of finesse to treat people kindly, to treat them decently, and to treat them fairly under the law.
Thank you. Ms. Benn?
My judicial philosophy includes following the law. As an assistant public defender, a lot of people think that my role is in condoning the behavior of my clients, and that is not what we do. We preserve their constitutional rights, their constitutional right to due process, their constitutional right to have a fair and impartial jury trial. That is what I do, and that is what judges have to do. Also, being fair and impartial and equal access to justice. So many of my clients include individuals who suffer from mental illness, intellectual disabilities, autism, addiction, substance abuse, alcoholism, and those individuals go into the courtroom being treated just as equally as everyone else. No favoritism, no treating anyone different based off of their socioeconomic status. In order to be assigned to their cases, my clients essentially have to be poor. They get treated equally in the courtroom. That is what I do, and I think that that will be a seamless transition for me as a judge, because that is what I do regularly.
Thank you. Next question, we'll start with Mr. Gaspard. As an attorney, how many jury and non-jury trials have you done? How does this affect your readiness to be a judge?
I can document 31 jury trials. Again, having been the training attorney at the state attorney's office, I can't tell you how many jury trials I've participated in excess of that. Every time I got a brand new trainee, I was either sitting second chair or acting principally on their behalf to ensure that a jury trial was conducted in accordance with the law. Obviously, I can't send someone in and go, here you go, good luck, and hope to goodness that they're able to do that without really creating a malfeasance of justice. So 31 that I can document, countless others. As far as non-jury trials, I've conducted 47 non-jury trials, both in the criminal arena as well as in the civil arena. Most recently doing risk protection orders, and how that would impact my ability to roll right into the job is, I've done it. I've tried the homicide cases. I know exactly what a 2.5-week voir dire, which is jury selection process, feels like. I know exactly what a 2-hour closing argument feels like. I know what the law is as it pertains to that. Having handled all manner of civil and criminal cases, I know what the cases look like, so I know how they should go. And so that would allow me to seamlessly transition into the role of a circuit judge without any lack of capability. Thank you.
Thank you. Mr. Siegel.
I do not know the numbers. I started at the public defender's office, so in private practice, I tried hundreds of jury and non-jury trials. At one point, I had a county judge that actually had me try 2 cases at one time. It was a DUI and a petty theft, which is kind of crazy. As a judge, I presided over criminal felony trials. I presided over divorce trials. And again, it's I believe to be in the hundreds. I cannot wrap my head around how you can do this job without actually having had the experience that they're asking you to discharge. We are trial judges. We should be trial attorneys before we become trial attorneys. And I think the thing you need to ask yourself is, if you're charged with a felony or you're in front of the circuit court for one of these very profound cases, do you want the least experienced attorney in the courtroom to be the judge?
Thank you, Ms. Fenn.
Jury trials, probably about 20. Again, that's everything from misdemeanors to murder trial. I have done, as well as the other candidates up here, I have tried, I've picked a jury, I've even assisted other attorneys as an assistant public defender, especially when I was a misdemeanor. Oftentimes you have attorneys who are new. They've just graduated from law school and passed the bar, and I was assigned, because I was more senior attorney, to assist them in their jury trial. So I sat second chair with them and essentially walked them through the jury trial process. So those 20 trials, I can't tell you if that was me as second chair assisting someone, or if it included, just mine. They were a combination of both. For non-jury trials, roughly 80, and that's because I have done civil and family as well. I've done the divorces, the child custody cases, child support matters, and those are bench trials. Those are trials before a judge. I've done civil cases, so I have a wealth of experience in both those areas, and would be ready as a judge to preside over them.
Thank you. Mr. Freeman.
I have gotten this question numerous times. I have not done a jury trial. I'm primarily a civil litigation attorney. 97% of the cases in civil litigation settle, and it's even higher outside of civil litigation. I'm not running for trial attorney. I don't think anybody up here would win best trial attorney if that was a vote. I'm running to be a judge. 95% of what a judge does is not involve jury trials. It's like saying you can't be an umpire because you don't throw a fastball. I can still call balls and strikes. I know what's right, what's wrong, and what's the law, and I know how to follow it. That's not an issue.
Thank you. Next question.
And we'll start with Mr. Siegel.
Okay, now you can hear me. Many criminal defendants are poor, and as a result, they find themselves represented by public defenders. Public defenders, in turn, find themselves with significant caseloads. What can a judge do to ensure that such a situation doesn't lead to inadequate representation?
First of all, I want everybody to understand that the people who work for the public defender's office, the people who work for the state attorney's office, are some of the best trial attorneys that you are likely to find. So, you hear things like public pretender. It isn't true. These are good, solid people. But the worst part, the thing that dogs the system the worst is the caseloads. Crime doesn't sleep, and it just keeps coming and coming and coming. And the problem is that delay is often seen as advantageous in working your case. Witnesses can't be found, their memories are lost. Sadly, people pass away, and cases oftentimes become better for one side than the other by the passage of time. If the court were to enforce a very strict time period on these cases, then these cases would come in and they would go out. And you could process cases coming in as quickly as you could process cases going out. So you would have qualified attorneys moving these cases along at a speed that allowed them to maintain manageable dockets.
Thank you, Ms. Vann.
So So this question was asked for me before, and it's always very difficult as an assistant public defender to answer this question in 90 seconds. I will try to do my best. There's a number of things you can do. As an assistant public defender, I mean, currently my caseload is about 150, but I've been in misdemeanor divisions where I was the only assistant public defender in that division and had upwards of 300 cases. I understand the need to progress cases forward so that they're not delayed, but as an assistant public defender who is juggling all of those cases, who has to watch body cam and dash cam, who has to meet with clients both in the office and at the jail, who has to file motions to suppress and stand your ground motions, who have to research those issues, it takes a lot of time, and it's time that is necessary in the office. In addition to that, I am in court most days. So although I understand the need to move cases forward, there has to be a step back where we give attorneys more time in the office to do office work. I am going to court for hearings that last five minutes. Let's put all of those on one day. I would suggest we do 2-3 days a month of short hearing days. Put all those on those one day, so I don't have to go to court for 5 or 10 minutes on Monday and Wednesday and Friday and juggle everything and schedule everything around having to go to court. That's why it's hard to do this in 9 minutes.
Thank you, Mr. Freeman.
Could you repeat the question, Kim?
Sure. Temperament, I'm sorry. Many criminal defendants are poor, and as a result, they find themselves represented by public defenders. Public defenders, in turn, find themselves with significant caseloads. What can a judge do to ensure that such a situation doesn't lead to inadequate representation?
First and foremost, the judge's duty is to protect the rights of the individuals. There can be, for the individual, it would be mapping out the case, making sure they understand each step that is going to take place and each step that is required. I don't know how many times people go into court, they're practically shaking. They have no idea what's going on, what's going to happen, and I never understand it. I'm always confused. Why don't we have some mechanism to explain to them, what's going on, and so that they have an idea of how this is going to progress forward. Whether it be calendaring or whatever, but making sure that they understand the steps that are taking place and why they're taking place, taking the time to make sure that they understand and that they have the representation that they need, and allowing them to ask questions, not going in there really quickly and banging the gavel or talking over them. And just, courtroom respect, following the law, following the statutes, and not, leaving people up to guesswork. It's very confusing. And, as an attorney, I've studied it for years, and I understand it, but I understand that most people do not.
Thank you, Mr. Gaspar.
Much like Judge Siegel said, I would agree. I've spent the majority of my career practicing against some of the finest attorneys that I've practiced with who were assistant public defenders. No qualms about saying that. They have given me those questions that make you scratch your head to no end. But that's because they are truly just as fine an attorney as anyone else. And I agree that they have a heavy caseload. As an assistant state attorney, I was carrying a caseload of 350 to 450 cases at a time. And we're the ones with the burden, back when I was an assistant state attorney. So I think there are a couple things. One, it's not for the judge to manage how someone gets represented, right? That's outside of our purview. We are there to ensure that the law is followed and to ensure that everyone is treated fairly. That being said, I think one thing that could be done better in the criminal arena that has been improved in the civil arena is scheduling orders. Yes, the rules of criminal procedure set out certain thresholds for us. Rule 3.220, the discovery rule, tells us you have to do discovery within this time frame, things like that. But then it kind of drops off and it stops, and there's no more guidance as to how we should move this case forward. And so as you've heard, sometimes these cases can progress ad nauseum. People kick the can down the road. And that is detrimental not just to the defendant, but to society and to any potential victims. There's an old adage that justice delayed is justice denied, and that is what is happening in certain cases. So I think if we have a better handle on scheduling and enforcement of that, we will be successful. Thank you.
Thank you. Okay. All right, everyone's had a chance to answer that, am I right? Okay. Okay, next question is we'll start with Ms. Vann. Temperament is a key element for judges and an area where they are often reprimanded. Describe an event that really angered you and how you dealt with it to respond professionally.
Thanks. So a lot of things come to mind, but I feel I would be remiss if I didn't bring up more recent acts. Many of you may know I was in a race for county judge, and the Friday before qualifying started, I was called at 4:30 in the evening and told that that race was now canceled and it would now go before the governor for appointment and non-election process. I had a weekend to think about it, and that's what I did. I took time for myself. I assessed my options, and that Monday I decided to run for circuit judge. I had ran for judge before in the circuit division, was prepared to do that again. Because my time was now limited, I could not mail my documents to ensure qualifying. I had to drive to Tallahassee on a Tuesday morning and hand deliver my documents to make sure that they were received by Friday noon. So I was given a matter of days to reassess, weigh my options, and that's what I did. And I think that that is key with a judge. Take time if you're upset, because I was obviously, it's upsetting. Take time away, take a breather, reassess, come back.
Mr. Freeman?
That upset me too, but I'm trying to think here I'll give you a specific example. When a judge does something and they act like they're obtuse about what they did or what the results are. I saw a judge one time chastise an attorney for not having a document notarized. And I looked at it and I thought I heard right, and they did it right in front of their client. And their client is sitting there listening to the judge basically dress down this attorney for something, and it dawned on me, and I later told them they didn't need to have the document notarized because they filed it directly with the clerk. And the judge, I just thought it was out of line. I didn't think it was right. They shouldn't have done that. And the client's looking at his attorney like, do you know what you're doing? And of course the attorney can't say anything. Can't say, hey judge, you're wrong, you don't know what you're talking about, or something like that. And it was later explained, as I understand, I don't know for sure, but it was later explained, nothing happened. No acknowledgement, no, that kind of stuff is bothersome. And I think it goes on way too much and gets disregarded, but it does have an impact. It does, it frightens people, especially when their lives are of consequence.
Thank you. Mr. Gaspar?
As attorneys, we have few things to hold dear to, and one of them is our integrity. I typically don't get angry. That's not really my style. But I've had a couple occasions where I've seen a little bit of red. And one time I was in court and I had an attorney make accusations about my truthfulness. Said I'd misrepresented something to the court. Well, I've been in a courtroom where I've seen a judge and a public defender get into fisticuffs, and I certainly don't condone that type of activity. So I basically stepped back. I asked the judge, can you please pull the video? Let's see exactly what I said. Let's hear what was actually recorded, because everything that happens in a courtroom is audio and video recorded. And the court did that. Got with the digital court reporter, pulled the video, we went back to chambers, we watched the video, and what I said is exactly what I said. If you can make sense of that, I dare you. And the allegation that was made was baseless. How else do you handle that other than saying, let's get to the truth? That attorney promptly left the division. at that person's own request. I still treated him with respect. I'm not going to lose my bar license for someone else's poor behavior. But I think ultimately it comes down to communication, respect, and being courteous, even when sometimes you're being attacked. Thank you.
Thank you. Mr. Siegel.
When I was a younger attorney, I was working for the Public Defender's Office, and I regularly appeared in front of Judge Tina Rainwater. I don't know if y'all know her. She's a fabulous judge. And I was the the young attorney full of sort of the spit and vinegar, and she'd regularly rule against me. I'd go back to the office and I'd pound my desk and I'd slam doors and I'd yell and I would scream, and it really was kind of stupid. But what I learned was that if I just sat down and I reviewed what she had done, why she had done it, I realized that every single time she was right. And I look forward to that, and I said, you know what? There are going to be things that hit me that viscerally are going to make me want to respond in a particular way. And I've learned to take that visceral reaction and just stop and just take a beat and then think about things. Apply the law, apply the procedures, think about what's going on, and take my time and reach a decision that's based upon logic, that's based upon thought, that's based upon reason, and not just because I'm upset.
Thank you. The next question will start with Mr. Freeman. What do you see as the greatest obstacle to justice? How do you plan to approach that problem?
I see an obstacle, and this is not my opinion alone, it's shared with many, many people. They feel like the system is stacked against them. They feel like there's an establishment, there's, for lack of a better description, a good old boys network, a way of doing things that nobody understands and is intentionally ambiguous and obtuse. I think that is a very concerning thing. Droves of people are turning away from our judicial system. We are now, last poll I saw by Gallup about a year ago said 35% reduction in confidence in our judicial system. It is at an all-time low, and that's not other people's fault. That's the system's fault. So that is, to me, the biggest obstacle for justice. I think it's out there. I think it wants to get through. I think there are plenty of great people who want to do it, but they feel outgunned. They feel outmaneuvered or shortchanged, or by a system that they feel is stacked against them inherently. And we need to change that. We need something new. We need something besides the establishment. And that's what I'm offering, is a different approach and a different skill set.
Mr. Gaspard?
Much like we just chatted about, I think probably the greatest challenge to justice right now is the overcrowded dockets. Recognizing that justice delayed is justice denied, that is something that is facing not just the criminal docket, but the civil docket. We were just at a forum over in Seminole County where the county court judges were advising they were each carrying a 4,500 caseload each. Those are staggering numbers. And they had worked diligently to get those numbers down, but that's not something unique to Seminole County. In the civil arena, they came up with the case management orders and case management plans. I think that is something that can be further refined. Certainly the input of the attorneys is imperative when doing that, because who knows best when they're going to be able to complete their discovery obligations, who knows best when they're going to be ready to get that pretrial conference done and get ready for a trial posture. But I think it comes back to the judge to be still moving that forward and to still be motivating the attorneys and the litigants. It may not be an attorney, it could be a pro se party, but motivating them to keep the cases moving. Active case management by a judge is something that can be used to address the stagnation and the size of the burgeoning dockets. And I think that's something that we should ultimately apply in both the civil arena and the criminal arena. Thank you.
Mr. Siegel?
I will tell you, the biggest problem is money. In the criminal system, people that can't afford an attorney, they're able to have an attorney appointed for them. And that puts them on parity with the person that's trying to prosecute them, and it gives them a really good fighting chance in court. In the division I'm in and all the other civil divisions, there is no similar provision. So you either can afford an attorney or you cannot afford an attorney. And look, think about me, whatever you want. Those people that work across the street in that courthouse, those are good, decent, honest people. They're not taking bribes. They're not taking money from people. They're not saying, hey, this person has an attorney and they're going to vote for me or they're going to send me a check, so I'm going to throw the case that way. That is not what goes on in our courthouse. That is not what goes on in our community. It is a very difficult situation to adhere to the law, to adhere to the rules, and try to make somebody who has no attorney, has no idea what's going on, feel as though they've been heard, when at the same time there's an attorney on the other side who either knows the rules very well and keeps their entire case out, or doesn't know the rules well enough, and just does whatever the heck they want because they know that the pro se party is not going to object. And as a judge, there's nothing we can do about that. We can't help people. We can't sit there and say, hey, look, sir, sorry, I feel bad for you. You don't have a lawyer. I'm going to help you. We can't do that. And that's one of the biggest problems that we have.
Thank you. Oh, Ms. Kennedy.
Yes. I echo Judge Siegel's sentiments in that money is the biggest obstacle. While in a criminal division, you have a constitutional right to an attorney. That part of your Miranda warnings that says if you cannot afford an attorney, one will be appointed to you. That's based off the Constitution for criminal cases. You do not have a constitutional right in a civil matter to have an attorney present. So much of that huge docket in part is because you have pro se litigants who don't have finances. They can't afford an attorney. They don't know how to litigate their case. They may not have money to obtain different things that they need for their defense or for their claim. And so that's part of the delay. And it's unfortunate. As a judge, you cannot give them legal advice. You can maybe point them into the direction of maybe resources that are available. Go to your local clerk of court office or the law library where they can assist you, but you can't give them advice, and that is a huge detriment for those individuals.
Thank you. Next question. We'll start with Mr. Gaspard, I believe. How do you avoid conflicts of interest, especially when seeking or accepting endorsements or donations to your campaign?
Well, first of all, seeking endorsements or contributions to my campaign, there are statutes and rules that govern that, and I can do neither of those things. As a judicial candidate, we are prohibited from seeking endorsements or the support of other attorneys. We are prohibited from soliciting any funds from anybody, and so I think that really is the first straw or the first step in ensuring that type of conflict protection. But that being said, we receive endorsements. I've received endorsements. I've received lots of endorsements from people who have practiced with me, from community members who know me. And I'm cognizant of that. There are people who I recognize, if a case comes up, there are certain people who may not be able to appear in front of me. And that is something that I would have no qualms about saying. You know, if one of my best friends is one of our deputies, if that individual were to have a case, I would certainly have to disclose immediately that that was the case, and I would have to look at either self-recusal or having a motion from one of the parties. I think it comes from being forthright, it comes from being honest, it comes from being realistic, that you know where your potential conflicts will lie, and not trying to hide that. Because again, all we have as attorneys, one of our fundamental features is our integrity. And if we lose that, we will not serve you. And I guarantee you, for me, you have that integrity.
Thank you. Mr. Siegel?
Yeah, so if you go on the division, the Department of State website, we have to report every penny that we're given. We report as a matter of pride the people that endorse us, but everybody knows everything that we've ever been given. I have to ask you to simply trust that when we tell you that we love doing this job, that I love doing this job, that I love the work that I do. I love following the rules. I love the way these cases play out. I love dealing with the people that I deal with. It's not because people are cutting me checks on the side. It's not because I'm violating the rules. It's not because I'm cheating. Games are no fun when you don't play by the rules. I mean, unless you have something concrete that says that just because somebody's received an endorsement from somebody else, they're going to be dishonest, then I really don't understand the question. But I will stand here and I will look each and every one of you in the eye and I will let you know I've accepted endorsements, I've accepted money from other people. It doesn't matter to me. When a case comes before me in the courtroom, it's a set of facts and it's the law, and that's the decision, and that's the end of it.
Thank you.
Can you read that question?
Sure. How do you avoid conflicts of interest, especially when seeking or accepting endorsements or donations to your campaign?
So, yes, the rules doesn't prohibit contributions and endorsements coming to our campaign. As it's been stated, we as judicial candidates can't go out and seek it, but we're not prohibited from our campaign receiving it. There's been endorsements and donations provided to my campaign, and it's come from individuals that have worked with me, individuals from just the community, people who I've met, and after speaking with me later decided they wanted to help. So that happens. I think it comes down to, like everyone else is saying, integrity. It doesn't create a conflict simply because someone has endorsed or donated to your campaign, but obviously if you have issues that are coming before you and you recognize that there is a conflict, it's internally your integrity and your willingness to speak up and say you have to recuse yourself from that matter.
Thank you. Mr. Freeman?
I'll tell you how I do it. I don't take any money from anyone. I am completely independent. I have not asked for nor will I accept any endorsements because, as I have been trained, it is not necessarily the wrong, but it's the appearance of wrong, and I will not have that in question. Regarding, the requirement for recusal, there is no statute requiring that a judge recuse themselves. It's an ethics issue, and it's up to the judge to make that decision. So the best way to avoid it in my mind is just don't do it. It looks terrible. The optics look awful. President Obama's campaign manager, I don't remember his name, he used to say that all the time. Look at the optics of what you're doing. And if you're taking money from people and they're arguing before you, and you're taking a lot of money from them, it looks poor, it looks bad, and it reflects poorly on the judicial system. So that's how I do it. I just don't do it.
Thank you. Next question. We'll start with Mr. Siegel. What are some effective methods for improving court procedures and efficiency? Where can you have an effect on these?
Okay. So it used to be in the family division that when you filed a notice for trial, it took about a year to get a trial date. We determined that that was not acceptable. And what we found was happening was that there was no active case management going on. That cases were getting filed, attorneys were filing motions, they were scheduling hearings. They were the ones that were driving the case. But what we have done, what I've done in the past about a year or so, is change those procedures. Right now it takes about half that time to get to trial. I'm not entirely proud of that, it's still a work in progress, but we've started managing the cases. We set case management conferences. We look to see where these cases are. And there are certain deadlines associated with these cases so that we know that if we schedule a case management conference within a certain period of time, certain things ought to be done. And if they're not done, we can order them to be done in short order, get the case to mediation to see if we can get these folks to settle, and if not, then we schedule a trial date. And we're scheduling a trial date on a date when we know that they're going to be ready for trial. This has proven tremendously effective. And like I said, it is still a work in progress.
Yes, Ms. Spann?
I think it comes down to calendaring and the civil sector, you have case management plans more outlined. In criminal, you don't. In criminal, I think it's case by case. I don't think you can have a hard and fast rule on how you are going to manage these cases because you don't know what's involved. And that's one of the things that I appreciate with certain judges is that if I come before the court and I explain why I need more time and why I'm not ready for trial, I expect that to be given some consideration because otherwise you are running to issues that is considered ineffective assistance of counsel. And what that creates is an appellate issue. Meaning, if I'm rushed into trial when I am not prepared and I'm not ready and I lose, now my client can come back and appeal because I was ineffective. So I think that there needs to be some consideration. It is case by case, and that's what I would do.
Mr. Freeman.
The issues are case by case, that's true. As far as efficiency goes, we need to look inward. We need to identify where there's redundancy, where there are things that may or may not be necessary, where we can accomplish maybe one or two things at the same time. Outlining is very important so that the individuals understand what is coming, what is next, what is expected of them, and being reasonable as far as accommodating reasonable requests and making sure that the rights are protected. That's paramount. Everything else is secondary.
Thank you. Mr. Gaspar?
I feel like I'm repeating myself a time or two, but active case management, honestly, to me is, I think, the biggest thing. I agree with Ms. Fant entirely. It's hard to ever have a bright line rule, this case is going to trial this day, come heck or high water. That doesn't honor an individual's due process rights. Everybody has a right to have their case heard in a timely fashion, but that also applies to the people on the other side. It's not just, we talk about defendants' rights an awful lot. We also need to be cognizant of the community's rights, the victims' rights. And so when cases aren't moving in a timely fashion, we're denying everybody rights. And so I think a judge who takes an active case management role will be more effective in moving cases effectively. I think a judge who uses thoughtful calendaring, much like Ms. Fant, when I was in circuit court actively every day as an assistant state attorney, I was there almost all day, every day. And I had almost no office time. I think thoughtful calendaring, giving attorneys an opportunity to have that office time so that they're not having to work nights and weekends every night and every weekend, is an invaluable tool. And that gives them an opportunity to make more effective use of their time, to meet with witnesses, to meet with victims, to meet with clients, and to perform the many functions of their role, to be adequately prepared for court when that case should come up. And so I think between active case management and thoughtful calendaring, we can improve our docket management. Thank you.
Okay. I believe all of you had a chance to answer that. Am I right?
Okay, we'll start the next question with Ms. Fant. Do you think that AI, artificial intelligence, is good or bad for the law and for the court system in general?
So both. I think that there will be some aspects of it that help and reduce delay, but obviously there are aspects of it that has created problems. There are issues where, obviously not me because I don't really use it, but there are issues that have arisen where there's been attorneys who have been reprimanded because they relied on AI. They submitted a legal document and the document contained case statutes that weren't actually cases. So I think it's gonna create some delay in some respect because now there needs to be an overview of that. But in other respects, it can reduce time. So it's both. Me personally, I go through the process of researching my own cases. I think it is educational for me to do that. I learn a lot when I do that myself. So I don't supplement that with AI, but I do understand that there are others who use it to help them manage their caseloads personally and to move cases forward.
Thank you. Mr. Freeman?
What was the question again exactly about AI?
Do you think that AI, artificial intelligence, is good or bad for the law and for the court system?
I think it's very good. I think, well, I know it's coming. There's nothing we can do about it. It's a tsunami. There are going to be challenges that we can't even imagine that are coming. I use AI routinely mainly for research, not for decision making, but it makes connections that you have no idea existed. To that effect, I think it's going to decimate the legal profession. I think that we're going to see a massive amount of attorneys exit the legal profession because the way they're practicing is not going to be, they're not going to be capable of doing what they've always done. AI is going to expose it. And I'm not the only one who thinks this. This is not my idea. It's going to show us connections and things that we've long suspected, but it's going to prove that are now true. As I can't imagine in the future there's going to be one kind of lawyer, lawyers who use artificial intelligence. That's it. I mean, anybody else is going to be in the left lane with their blinker on. I mean, it's just, you're not going to be able to avoid it. The challenges it's going to present is everybody's going to become an attorney, right? They're going to argue their own cases. They're going to do a lot of that stuff. And, you know, we can see that. We can do that. We can handle that. We can, if we take steps now and we address it. The legal profession is slow. It's very slow to change. Sorry.
Thank you. Mr. Gaspard?
AI is both a good thing and a bad thing. I think that's hard to say, but I think with good comes the bad. I'm certainly concerned about generative AI, which is where the artificial intelligence can pull from out in the world and condense knowledge. I have had the occasion to see, much as Ms. Fant had discussed, I've seen an attorney who's been held in contempt by the Federal District Court for the Middle District of Florida over in Orlando for filing a pleading that had absolutely completely hallucinated quotes and absolutely completely hallucinated case citations, cases that didn't exist, cases that did exist that didn't stand for the proposition that were alleged. That's terrifying, but that is negligence on an attorney's part. I use AI in limited scope. There are a number of research tools that are out there, such as Westlaw, LexisNexis, things of those natures. Those are a closed network, and what it does is it allows me to, once I finish my writing, because I research and write everything from scratch, but it allows me to run it through and go, hey, check me, make sure all of my quotations are accurate to the actual cases, make sure that all of my case citations are accurate, because sometimes you get typing and you fat finger something. And it's a wonderful tool in that limited scope, but the thought of using it for generative purposes terrifies me. I have seen people argue law that is wholly inapplicable to the subject matter that's before them because AI told them it was right.
Mr. Siegel?
AI is really cool and really terrible. People that are not represented by an attorney, they're filing what used to be 3 or 4 page motions. They're 45, 50 pages long. And when they get before you to argue them, they have no idea what the motions say. Forget about whether the case law is correct. They don't have any idea what they've asked the computer to do for them. We have the problem that everybody else has identified as using case law that's just completely made up. On the other side, there is some really neat stuff going on with AI. I know a lot of small claims courts use AI for mediation purposes. People have no idea that when they're dealing with a mediator on an online experience, that's not a person. That actually is a computer program that's able to deal with these sort of low-level problems and mediate disputes between people that they're happy with. There are situations where we're talking about people not having enough money to go against the big attorney. But now when the big attorney drops 300 boxes of information on your desk, you can feed that into a scanner, type in a prompt, and you can process all of those documents in just a couple of minutes. It's being used in risk assessment purposes to try to determine what level of risk somebody poses for purposes of releasing them on bail, on probation. I'm not saying that I use that as a substitute for my own judgment, but these are things that are coming that they're finding that they're using all over the place in the law.
Thank you. I believe this will be the last question for this evening, and then we'll go to openings or closing statements. The next one, would it be beneficial to know which party the judge is affiliated with? And we'll start with Mr. Freeman.
It would be if the judge couldn't control themselves and made personal judgment, let their personal beliefs and let their personal opinions influence their decision when it comes to following the law and the Constitution. In that respect, I think it would be. But guaranteeing a judge is going to go one way or the other, I mean, how many times have we seen Supreme Court justices appointed by somebody from a party and they follow, I don't know what they follow, but I don't think it's a guarantee that you're going to get what you think you're getting. So in that respect, I don't think it's terribly important.
Thank you. Mr. Gaspard?
Canon 7 prohibits it, and I think for honestly a very valid purpose. When you have a judge, that is an individual who is, for all intents and purposes, a neutral gatekeeper. And that is what you want them to be. You want them to be completely neutral. You want them to be completely impartial, or as impartial as humanly possible, right? We all have our implicit biases that we have to recognize to be able to address to ensure that we're not allowing them to influence our decision making. But I think if we were to publicize political affiliations, then that could generate the appearance of impropriety, even if there is no impropriety existing. Someone would be like, oh, well, I don't want that person because they belong to this party, or no party, or that party. And I can't trust that they're gonna rule consistent with the law, even though that person, regardless of their party affiliation, would still faithfully apply the law as it's written. And so I get why Canon 7 exists. I get why the law precludes us from it. I think the ultimate consideration for our constituents, the community, is find a judge who's going to follow the law, who will be fair, impartial, and professional on the bench. And when you find that person, cherish them, regardless of their party affiliation.
Mr. Siegel?
Yeah, pretty much what's been said so far. You don't want to walk into court and know that the judge is already thinking something about your case, other than perhaps what's been read in the court file. You don't want them thinking, well, I'm a Democrat, so this is the way I think. I'm a Republican, this is how I think. You want that judge to listen to your case, to listen to your facts, to apply the law as it's written, as it's been interpreted in our case law by precedent, make decisions solely upon those factors, not because what the judge wants, what the judge thinks, what the community wants, what the community thinks. It's because this is what the facts of your case are, and this is what the law is.
Thank you, Ms. Ann.
I echo what's been said before. I realize that many individuals want to know that information. As what's been said before, the judicial canons prevent us from communicating that information with anyone, but it doesn't come up in court. I mean, I'm in court often. No one knows anybody's party affiliations, and I don't know my clients' party affiliations. They don't know mine. It doesn't come up. You want a judge to look at a person and just base it on the law and the circumstances and the facts and be fair and impartial and not know anything politically or personally about them.
Thank you. Now we'll start with closing statements. And we start with Mr. Gaspard.
First, I'd like to say thank you to the League of Women Voters and to all of you for coming out this evening. Engaging in this process has been eye-opening. My whole career, I never knew judicial forums were a thing, because I always knew who was running. I think it comes down to two things. First of all, you need a judge who is experienced and capable of handling the matters that are going to come before the circuit court. I bring you that experience. I have handled almost every single type of law that appears before a circuit judge. And I actively handle those matters at the Brevard County Sheriff's Office. In addition, I have 6 years of experience as a civil mediator, handling matters as a neutral. So that has provided me additional experience to bring that neutrality and that impartiality to the bench. Folks, I've served you as a community as an assistant state attorney. I've served you as a community as your legal counsel for the Brevard County Sheriff's Office, ensuring that our law enforcement officers are performing their duties in compliance with the Constitution of the United States and the Constitution of the state of Florida and the laws that govern us. And I'm looking to serve you as your next circuit judge. And I'd be very grateful for your support by voting for me on August 18th. Please vote George Gaspar for judge. Thank you.
Thank you, Mr. Siegel.
Good evening, folks. Thanks for giving us the opportunity to speak to you a little bit this evening. I've been a circuit judge now for 8 years. I have been the administrative judge of the family division. I've been the administrative judge of the appellate division. I run the adult drug court. I recently won an award for judicial excellence and professionalism that was awarded to me by the Brevard County Bar Association. If we're going to talk about endorsements, I'm endorsed by the sheriff, the public defender, the state attorney, the sheriff in Seminole County, the Police Benevolent Association, all of the past presidents of the Brevard County Bar Association. These endorsements didn't come from me asking for them. They came from people wanting somebody who is skilled at this job to remain in this position. As I've told you before, and I will tell you again, I love this job. I love the work that I do, and I would love to be able to continue to serve you as a circuit judge.
Thank you, Ms. Vance.
Yes, so I'm asking for your vote on August 18th. I have a wealth of experience, over 16 years of experience as an attorney, civil, family, criminal. I've done divorces, murder, all those different type of cases. So obviously have a lot of experience. But I'm also running because I want to improve the system. Going into the courtroom every day as an assistant public, or nearly every day as an assistant public defender, I grew frustrated. I saw the strengths in our system, but I also saw the weaknesses. And I was that person going back to my office, screaming, crying, and getting frustrated and complaining. And I thought, enough of complaining, because the complaining isn't helping anything. And so I put my name in with a mission to do what I could to improve the weaknesses that we have. So I'm not doing this because it's just the next progression in my career, or to pad my resume or anything like that. I'm doing it on a mission. I was tired of complaining, and I thought I'm gonna do something about it. And so I am asking for your vote on August 18th.
Thank you. Mr. Freeman?
Thank you for having me. The reason I'm running and the reason I'm asking for your support is I believe we need something new. We need something that is ready to meet the challenges that are coming. Seniors have a target on their back. We need something that's not out of an establishment. I've heard arguments against me. I'm not experienced, and various other things online. Those are tired establishment arguments that have been used to block the paths of minority and women since the time of the pharaohs. We need something new, and if you've been there for 20 years, you've either done what you're going to do or you haven't done it yet, which you don't need another 20 years. We need something new. People are desperate. They come up to me all the time and they grab me and they tell me, thank you for doing what you're doing. Thank you for challenging. Thank you for giving us a new option. I'm completely independent. I don't take any money. I haven't played for either side. It's very important that we maintain that neutrality, and not only that, the appearance of that neutrality. People are frustrated and they're turning away from the system. We have a chance to bring things back, to right the ship, and that's what I'm asking you to help me do. And I will do it. I will execute the duties faithfully and honestly and with integrity. I will protect our Constitution, both our U.S. and Florida Constitution. I will follow the law. I will not legislate from the bench. It's a calling, not a career for me. I will pledge to finish out my term fully and not turn it back over to the ballot where I believe it belongs. I'm asking for your support, and I'm asking for you to try something new, and otherwise it's the same old.
I would like to thank our candidates for coming out tonight. And so let's give them a round of applause. There will be time. There are cookies in the bag still, I'm pretty sure, and water. And candidates, you're all welcome to converse with the constituents here in an informal way. I'm sure many would like to meet you. And I just thank you again. Upcoming events for the league. On August 15th, we are at Century Vieira Library, and we are going to have a panel discussion about property taxes with Lisa Cullen and Dana Blickley, and you're all welcome to come. It's from 1:30 to 3:30. 1:30 to 3:30 at the public library here in town. It is a hot topic, isn't it? Okay, that's it for this evening, and I want to thank my volunteers. You were great tonight. Thank you for keeping the order.
I would like to meet each and every one of you if you have a chance.